Mr. President, I want to speak in support of the DISCLOSE Act. If there is one thing that Democrats and Republicans should be able to agree on, it is that our campaign finance system is broken. My colleague from Rhode Island made that point earlier, and I certainly agree with that. With the Supreme Court's decision in Citizens United, corporations, unions, and other groups are able to raise millions of dollars through secret contributions and spend unlimited amounts of money to influence federal elections, as long as they do not directly coordinate with a candidate. According to the Federal Election Commission, it's expected that something over $11 billion will be spent over the course of the 2012 elections. That's about twice the 2008 level of spending. This is a staggering amount of money, and the source of much of that money will be completely in the dark. As a result, extraordinarily well-financed special interest groups dominate the airwaves, and it is nearly impossible for the average citizen to know who is behind campaign ads. In fact, it's nearly impossible for experts to know who is behind particular campaign ads. This is not good for public discourse, and it is not good for our democracy. In a healthy democracy, voters need to be able to make informed decisions about the information that's presented to them. And the lack of transparency that currently exists in our political system makes that incredibly difficult. I strongly disagree with the Supreme Court's ruling in the Citizens United case. But the reality is that short of a constitutional amendment or a decision by the court to reverse its opinion, both occurrences are unlikely anytime in the near future. The ability of Congress to restrict independent expenditures is very limited. But there is something that we can do now and that would make a difference. We can enhance transparency with respect to the high volume spending that is influencing our elections. We may not be able to stop the flood of unlimited spending, but we can shed some light on this process and enable the public to at least see where the money's coming from. The enactment of legislation requiring greater transparency about who is spending on campaigns was specifically called for by the Supreme Court in the Citizens United decision. Republican leader here in the Senate has argued against the DISCLOSE Act on the theory that it would squelch political speech. Mr. President, I'd ask unanimous consent to include in the record, following my remarks, an opinion piece in Politico this morning entitled "Mitch McConnell Dead Wrong on DISCLOSE Act." It was written by Adam Skaggs, the senior counsel for the Democracy Program at the Brennan Center for Justice at the New York University School of Law.
Without objection.
In that opinion piece, Mr. Skaggs points out that there is no legal or logical basis to support the Republican leader's argument. The DISCLOSE Act is an important step in the direction of requiring transparency. The legislation would require certain organizations that make more than $10,000 in campaign-related expenditures to file a disclosure report with the Federal Election Commission and to report the names of any donors who contributed over $10,000. About 93% of the money raised by super PACs in 2010 through 2011 came from donors giving over $10,000. And this legislation would shed some light on where this money is coming from. The disclosure requirements apply to corporations, to labor unions, to 501c3 nonprofit organizations, and to 527 election advocacy organizations, but they would not apply to 503c3 charitable organizations. The legislation also includes mechanisms to protect legitimate non-political donations from disclosure and prevents funding sources from being hidden by laundering funds through third-party groups. Mr. President, it's clear that our campaign laws are outdated. They are in desperate need of revision. Frankly, I wish there was a consensus in Congress to make more fundamental reforms to our campaign finance system than we are considering today. Unfortunately, this is not presently the case. But I would hope that we could build bipartisan support for some basic disclosure provisions and for this narrowly tailored bill that is pending here in the Senate. A much more comprehensive version of the disclosed law was filibustered by Republicans in 2010, and the revised version that we're currently debating has been narrowed significantly. The provisions banning campaign spending by foreign entities and government contractors were removed. Corporate campaign spending is no longer required to be reported to shareholders, and lobbyists won't have to report their campaign spending in their annual disclosure reports under the bill being considered here in the Senate. The new bill also raises the disclosure trigger from $600 to $10,000 to focus only on large donations and to reduce the burden on organizations. And the newest version dropped the stand by your ad provision that required the listing of donors in TV and radio ads. I'm not unsympathetic to First Amendment concerns regarding the rights of politically active groups that want to be engaged in the discussions regarding the future of our country. But enabling corporations and special interest groups to use what are essentially shell organizations for the simple purpose of spending vast sums of money to influence elections, and to do so in secret, is incredibly harmful to our democracy. Requiring the disclosure of large donors is a reasonable mechanism to maintain the integrity of our electoral system without infringing on the ability of organizations to actively participate. I urge my colleagues on both sides of the political aisle to take this opportunity to support the modest but important reforms that are included in the DISCLOSE Act. Mr. President, I yield the floor.